Title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land.
Free and special appearance, she says. That may be how she's labeling herself right now, but that stance won't hold for long as this hearing moves forward. Those claims are about to be tested against actual courtroom rules and legal standards.
I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray All
right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime my autograph is to be done in a certain manner that I have here, or it's forgery. Could you ask the judge, please? That's my name. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan, beneficiary, with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it.
That's fine, Your Honor. The moment the plea offer comes up, the tone of the hearing shifts. People aligned with these sovereign-style arguments tend to trust advice only from others who share the same beliefs, often ignoring guidance grounded in actual law and procedure. Now the prosecutor carefully lays out the plea deal, and it is remarkably generous by any courtroom standard that IT offers a clear path forward with reduced consequences and a chance to resolve the matter efficiently. Yet, despite how favorable it is, she rejects the offer outright, staying consistent with her approach and choosing ideology over practicality, even when the outcome is clearly working against her.
Mr. Marvin, is there a plea offer here?
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds, but what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her, I've kind of hatched this plan, and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for a prelim.
Let me break down just how generous this offer really is, because it doesn't get much better than this. First and most importantly, the prosecutor is willing to reduce a felony charge down to a misdemeanor, which is already a major step in her favor. That alone significantly lowers the long-term impact this case could have had on her record and future. Second, the separate misdemeanor charge she was already facing would be dismissed entirely. That means one charge reduced and the other removed, cutting the case down to a fraction of what it started as. Few defendants are offered that kind of relief, especially at this stage of the process. Finally, there's a clean slate opportunity built in. If she stays out of trouble for the next 6 months, even that reduced misdemeanor would be cleared from her record. In simple terms, she has a clear path to walk away with no lasting criminal history at all. Honestly, this deal is exceptionally lenient, almost unheard of in similar cases, and Judge Middleton appears to recognize just how fair, perhaps overly fair, the offer truly is.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charges.
Mr. Marvin, let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the?
It's a benefit. And
No, before that, about the license.
He's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm
on
not
a
playing
prelim.
games. I'm serious.
You are playing games. And first of all,
I'm
you don't.
trying to advance to
All right,
what I'm
stop.
here.
You don't interrupt the judge, whether you're a flat earther or not.
I'm not flat earth, sir.
All right, well,
Well, here we go again, this time with a flat earth argument entering the conversation. Over time, this channel has examined many different belief systems that clash with established facts, but flat earth claims and sovereign-style arguments stand out for a very specific reason. Both are built almost entirely on rejection of evidence rather than engagement with it. What makes these moments striking is not just the claim itself, but the confidence with which it's presented. even when it contradicts settled science or long-standing law. Instead of relying on verifiable proof, these positions often depend on personal conviction and selective interpretation. That gap between belief and reality is what turns the discussion from a debate into a clear demonstration of how misinformation can take hold and persist.
All this crazy stuff you're saying, I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So, do you wish to represent yourself, or would you like me to get an attorney to assist you with this?
It's my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do
And
you
I-
want me to appoint an attorney for you, or would you like to represent yourself?
So may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case.
The very fact that you had to ask whether the court has criminal jurisdiction says everything that needs to be said. That question alone shows a clear misunderstanding of how the legal system works and where authority actually comes from. At this stage, it's a strong signal that the argument being made is well outside established law. Sometimes, the only way a misunderstanding is corrected is through real-world consequences. When someone refuses to accept basic principles, whether scientific or legal, no explanation ever seems to be enough on its own in the courtroom. That reality becomes unavoidable because jurisdiction is not a theory or a belief. It's a legal fact enforced by the court's authority.
Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
How thoughtful of you to be polite now, especially after delivering a long explanation without much context beforehand. You did ask formally for a written copy of the Michigan Civil Rules of Procedure. And yes, those rules are publicly available online. They can be found in Chapter 2 of the Michigan Court Rules for anyone who wants to look them up. However, that request misses the point entirely. Those civil rules do not apply here and won't assist your position in any meaningful way. This matter is not a civil dispute. It is a criminal case, governed by a completely different set of standards. The procedures that actually control this hearing are laid out in Chapter 6 of the same Michigan Court Rules, which specifically address criminal procedure and define how this court must proceed.
Thank you. It's not civil procedure, it's criminal procedure. And the defendant doesn't come up and show, court, tell me why I get to do this. You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report bond information that came with the file. So what would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
the next question is, are you willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure under admiralty or military tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop.
If I were in your position, I would stop speaking immediately. Judge Middleton has made it clear that he is not entertaining side arguments or procedural games. Every extra word only seems to deepen the situation rather than improve it. At this point, the inability to remain silent is becoming a serious problem. What could have been handled calmly is now escalating because courtroom warnings are being ignored. Unless that changes quickly, This pattern of interruptions is about to result in an immediate and very real consequence: time spent in custody.
If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going to talk about this tomorrow at 3 o'clock. I find that you're in contempt. You're going to jail right now, and we will. Well, you have been.
I'm simply
This matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
Well, you can think about it
And we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3 o'clock. And you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you.
go
If you wanna
with the
continue-
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We will address this tomorrow at 3 o'clock.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
I'll be more than happy to. She's going into custody for contempt.
Okay, let's go this way.
Earlier in the video, some of you may have noticed the prosecutor briefly mentioned that her son was present in the courtroom. That detail becomes important later, because he happens to share the same sovereign-style beliefs that were already on display during the hearing. His presence did not go unnoticed, and it added another layer to the moment. Judge Middleton chose to address him directly, using the opportunity to speak plainly and without theatrics. It wasn't a lecture filled with anger, but a firm reminder about how the court operates and what happens when legal authority is ignored. The message was clear and direct, aimed at making sure there was no confusion about reality, responsibility, and the consequences that come with rejecting both.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was just a misunderstanding of how for her to be able to pronounce that.
Well, I told her to stop and she didn't stop. And she doesn't know what she's doing. She needs a lawyer. And she's going to contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock. And to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record. And all she wants to do is argue about admin fees.
Judge Middleton stayed calm, firm, and completely unshaken. That steady, no-nonsense approach is exactly how situations like this are meant to be handled in a courtroom. There was no need for raised voices or theatrics, just clear authority and strict adherence to the LAW, while keeping emotions out of it and focusing on facts and procedure. The judge set the tone from start to finish. It showed how effective the justice system can be when boundaries are enforced consistently and professionally. All right, everyone, that brings us to the end of the video. Thanks for watching, and we'll see you in the next one.